What to do if your ETIAS application is rejected. ETIAS, also known as the European Traveller Information Authorization System, is a new method of electronic travel authorization that will be implemented in all European Union countries, together with the Swiss Confederation, Iceland, and Norway, in November of this year. Before entering the European Union or the EEA or the Swiss Confederation, you will need to fill out an online form. That being said, if you are from a country that does not require a visa to enter the European Union and that you're not staying for more than 90 days, you will need to fill out an electronic application form and pay a €5 application fee. Your details will be then searched via the Interpol database, the Schengen Information System, and also national law enforcement databases. If your ETIAS application is rejected, do not panic. You will need to apply for a Schengen visa at your nearest consulate of a European Union member state, or the European Union member state you're thinking of visiting. You will then need to provide an application form, submit your biometric details, and mention to the consular officer why you are applying for a Schengen visa. If your ETIAS application has been rejected, it is most likely because you either have prior criminal convictions. In this case, we will explore what to do if you have prior criminal convictions and want to visit the European Union after November 2025. First of all, most European Union countries have statutes of limitation for how long criminal records can be processed in the actual databases. If you have ever been convicted of a crime outside the European Union, it will be determined if you possess a possible risk to all the European Union member states. If you have been convicted of a crime that is of extreme violence or violence, the chances are that you will be inadmissible to the European Union for life. If you have been convicted in a European Union member state after the 7th of April 2012, your data will be in the European Criminal Records Information System, also known as ECRIS. If you have been convicted for a non-violent crime in the European Union and the statutes of limitations have not passed, and as part of your sentence you were not given a supplementary sentence of prohibition of entering the European Union, you will need to demonstrate to the consular officer that you do not longer possess a threat to the EU member states in the case of any criminal wrongdoings. If your ETIAS application has been rejected and following you applied for a Schengen visa, either a Type C or a Type D, and if that has also been rejected, there is a last route or a last solution that you can take. And that is that the matter goes under judicial review in the country that you're applying for a visa or who wants to issue a Schengen visa. That would then be valid for all European Union member states with the exception of Cyprus. A judicial review is usually a review that is conducted by the administrative court of the country that rejected your visa application. In most cases, the administrative court will then decide if the consular officer acted within the legal frameworks, both national and European Union frameworks, and in that case, it can come to a positive conclusion on your part. So I would strongly advise that if your ETIAS application has been rejected together with a Schengen visa refusal, that you seek the judicial review in the country that you're applying to.